Hello, my name's Ken Novenstern. I'm a partner in Fredman, Baken, and Novenstern LLP, and I'm doing the second part of another series. I think this is the third series that I have recently done with Melissa Goodstein, and Melissa will be the president of the New York Association of Collaborative Professionals starting in January 2023, and I am president finishing out my term in 2022. And so it's a pleasure doing these series with Melissa, and hopefully I can keep up with her excellent example. So Melissa spoke to the first meeting in a collaborative divorce process and talked about such things as the collaborative participation agreement, and importantly, setting the stage for the attorneys better understanding the concerns of the parties, their goals, their interests, what's most important to them with respect to the family going forward. There are issues and agenda that would be prepared at the first meeting for what will be done in the second meeting, and oftentimes that agenda includes addressing specific interests and concerns of the parties, addressing any immediate issues. And some of those immediate issues would include things like oftentimes one party or both parties want one party to move out of the house, and what would that look like, and that it would be without prejudice to the rights of the party moving out as it relates to custody and possibly other issues. And the party who's staying in the home with the children often has the concern about making sure that the status quo is maintained with respect to paying bills. So if there were a stipulation done, oftentimes we start to address the bills to be paid and making sure that there's some coordination with respect to finances. In addition, at the second meeting, very often we would confirm the team. So the team includes the parties, their collaborative counsel, and also a financial neutral, one or more mental health professionals. And so the selection of those individuals might not be complete as part of the first meeting, and oftentimes that's addressed in the second meeting. Then going through the interests and concerns of the parties, it really becomes a little bit fluid because we have to figure out what those interests and concerns are. And some cases are more complicated, and so we have to address that. We would also then start laying the groundwork for the financial neutral, getting information from the parties to give to the financial neutral. And finally, we would set our own agenda for the next meeting. The real goal of all of these meetings is to get a strong understanding of what's most important to the parties and what we can do to facilitate the process, give them a greater degree of comfort, and help them recognize that they have some control over this process, that they have much more control over this process than if they were in a litigated process. So please don't hesitate to contact me with questions concerning the first meeting or the second meeting or anything having to do with collaborative divorce. I look forward to speaking with you, and take care.